Hi, I'm James Minick, and today we're going to talk about attacking reasonable suspicion in the context of a DWI investigation in North Carolina. Whenever you begin an argument regarding the presence or absence of reasonable suspicion, in our case with defending a DWI, the absence of reasonable suspicion, make sure that your starting point is the Constitution. Don't start with an administrative code. Do not start with a statute. Do not start with a North Carolina specific case. Begin your attack based on the United States Constitution. The Fourth Amendment protects individuals against unreasonable searches and seizures. Remind the judge of that. Begin there. Begin with the argument that this is not some sort of a procedural or technicality in terms of why my client should not have been stopped. It's a constitutional violation. It's a violation of fundamental rights that were identified by our founders. Don't begin with something more recent. Begin with your most solid ground, which is the Constitution. Some stops might be based on a traffic infraction or a traffic violation. However, an officer may stop a driver that has not committed a actual traffic infraction with the belief that that person is exhibiting signs of an impaired person, that the driver is impaired based on a non-infraction basis. When that is the situation, that is a stop based on reasonable suspicion, not on probable cause for an infraction, and is akin to a Terry stop. Such a stop, quote, must be based on specific and articulable facts as well as the rational inferences from those facts as viewed through the eyes of a reasonable, cautious officer guided by his experience and training. When you're making an attack to a case based on lack of reasonable suspicion, identify those elements and have your cross-examination be based on those elements. Is the stop reasonable? Can you make logical arguments for the suspicion? Is there specificity? Was there specific factual basis for making the stop? Don't just point to vague and general facts. Make sure for example, there's been criminal activity in the area. This is a high drug crime area. What are the specific facts for which the stop was made that led the officer to believe this person was impaired? Remind your court that that definition includes cautious officer, so a careful officer. This is not a situation where the officer should be kind of erring on the side of violating somebody's constitutional protections. Carefulness, cautiousness is an officer that is trying to get as much information as the officer can prior to making a stop. If the officer has followed your client for 5 miles before deciding, okay, I'm going to make this stop based on what I've seen, that is a different situation than the officer has been observing your client for a block and says, I think I'll just go ahead and make a stop to just see what's going on. Remind your court that the officer in the context of reasonable suspicion is supposed to be a cautious officer. Also, knowledge, basically experience and training. How is the officer using his experience and training in determining whether or not a stop would be appropriate? Also remind your court from State versus Robertson that evaluation of any suspicious driving behavior must still be evaluated against the backdrop of everyday driving experience. So we're not looking at this in the context of just a blank slate. What do we normally see from drivers? What do we see from distracted drivers? What do we see from drivers at particular points in the community where there might be issues routinely observed? This needs to be evaluated against the backdrop of everyday driving experience. The National Highway Traffic Safety Administration has specifically identified 24 clues that would potentially be indicative of an impaired driver. Those are laid out in student manuals that are received by officers when they're trained to investigate DWIs, these are standard clues. They're broken down into 4 categories: problems maintaining proper lane position, speed and braking problems, vigilance problems, and judgment problems. Go through each of those different categories and see what might be present in your particular case and what might be lacking. Probably the most common reason that a client is pulled over is for DWI is for speeding, and speeding is not one of these 24 clues of impairment. It may be very much a grounds to stop somebody if the officer can articulate how he estimated speed and his training in estimating speeds and those type of things, but in terms of being an indicator of impairment, it is not. So point that out to the court in the context of a PC motion where speeding is included. In terms of the 2 clues specifically that are helpful in a context where there's no traffic violation observed, the last 2 clues in the manual are important to look at. One of them is inappropriate or unusual behavior. And several of the student manuals define that as throwing objects from the vehicle, drinking in the vehicle, urinating at the roadside, arguing without cause, or other disorderly actions. So this is something that the officer is observing prior to the stop as the driver is in motion. The other one, and the final clue, is appearing to be impaired. And the student manual from 2010, the NHTSA student manual gives examples of eye fixation, tightly gripping the steering wheel, slouching in the seat, gesturing erratically or obscenely, face close to the windshield, or driver's head protruding from the vehicle. Both of these clues and the examples that are based on these clues seem kind of absurd. It seems like this is clearly a drunk person, but what you want to remind the court of is that this is the training that is received by the officers to be looking for these things. It's not kind of a fine line of, well, maybe this is a judgment call about whether or not this person is impaired. These are clues that an ordinary person might be able to look at and say, that is extremely unusual behavior. This is a person that appears on the face of things to be impaired. And again, for an officer that kind of immediately stops somebody based on the suspicion that they're driving, ask, did you see these things? Did you look for these things? And again, it's not only a matter of whether or not they've seen that, but whether or not they've even looked for it. That could be helpful in determining whether or not reasonable suspicion was appropriate. A cautious officer would have tried to identify whether or not these clues were present, get as much information as he could before making a stop that is a seizure of the individual. In regards to some of these clues, also remind your court that North Carolina law trumps the 24 clues that are laid out by the National Highway Traffic Safety Administration, and I'll give a couple of examples of that. One of the 24 clues identified by NHTSA is the clue of weaving. Weaving within one's lane, weaving outside of one's lane. North Carolina specifically has stated that weaving within one's lane is not enough in and of itself to stop somebody based on suspicion of impaired driving. Other factors combined with weaving may be enough to get to reasonable suspicion, but weaving alone is not enough if it's within one's lane. Slow response to slow response to traffic signals is another clue identified by NHTSA. North Carolina has specifically held that an 8 to 10 second delay at a traffic light is not an unusual amount of time for delay and does not give reasonable suspicion for stopping somebody for impaired driving. that motorists often delay at a stoplight and are doing other things and become distracted, and so that is not enough. So again, while that is a clue that is identified by NHTSA, North Carolina specifically has held that would not give reasonable suspicion. There's a couple of situations where reasonable suspicion would not be necessary to find. One of those would be in a situation where there is a consensual encounter between the suspect and the police. So where they're arguing there was no stop, there was just basically a consensual encounter. These are pretty rare in the context of driving cases because generally the person is in a vehicle, but it is possible that there might be an argument that there was a consensual encounter from the state. Another situation would be where the state argues that there is a community caretaking function going on, and so it was not really a stop, but really basically the officers exercising their looking out for public safety and welfare, and this was not a constitutional stop. State versus Smathers lays out what the state bears the burden of proving if the community caretaking doctrine is going to apply. It's the state that bears the burden of proof to show that there was a applicable, appropriate utilization of community caretaking doctrine. In an accident context, again, no need to have reasonable suspicion in terms of responding to that. There may be some issues in terms of how long before the accident occurred, if the suspect is no longer near the scene of the accident, or if it's been a long time since the accident occurred, so that might be an issue. But in terms of responding to the accident, no reasonable suspicion necessary. And in the context of a proper constitutionally conducted checkpoint, then in that particular situation, reasonable suspicion would not need to be employed. So again, in terms of attacking a DWI where the attack is based on reasonable suspicion, again, remind your court that we're starting with the Constitution. Is this a constitutional violation? Use that language of, is this within the realm of normal driving behavior? Remember the elements of what reasonable suspicion includes, that there has to be particularity, that this is based on the officer's training experience, that this officer is a cautious officer. So remind your court and base your cross-examination questions around that, and then look to NHTSA to see if any of those violations are present, and also use that to bring out, you are a trained officer to look for these 24 clues. You didn't see X, Y, Z, go through each of the 24 clues. You didn't see this, you didn't see this, you didn't see this. And basically remind the court these are things that the officer is trained to look for in the context of a suspect that is believed to be driving while impaired. Those things weren't seen, or they were not looked for by the officer in this particular context.